In re Judith Miller, National Security and the Reporter's Privilege, a program planned and developed by the Historical Society of the District of Columbia Circuit, with video produced by the Federal Judicial Center, February 14, 2017. David Posen, professor of law, Columbia University, sets the stage for In re Judith Miller, followed by a reenactment of the argument before the U.S. Court of Appeals for the District of Columbia Circuit. The reenactment is led off by Laura R. Hanman arguing for Ms. Miller and Amy Jeffress arguing for the government, with Judges David S. Tatel and David R. Sentel of the U.S. Court of Appeals for the D.C. Circuit presiding. The program concludes with a panel discussion among Professor Posen, Ms. Hanman, Ms. Jeffress, and former Deputy Attorney General James M. Cole, moderated by Stuart S. Taylor, Jr. And now introducing the program, Jeffrey M. Kleinberg, Chair of the Program Committee of the Historical Society of the D.C. Circuit.
I am delighted to welcome you here today for our program in the case of In re Judith Miller, National Security and the Reporter's Privilege. The handout that you were given today includes a brief summary and background of the case and a description of the participants. And for those of you who have been to our programs before, the format will be familiar. We will begin with a talk to provide some context for the case and of the issues that the case raises. And we will then follow with a reenactment of the 2004 oral argument in re Grand Jury Subpoena Judith Miller, focusing on whether the common law recognizes a reporter's privilege to safeguard the identity of her sources. And we will conclude with a panel discussion to address some of the implications of the case and how best to think about balancing national security with the public's need for information. So, it is my great pleasure to introduce to you Professor David Posen of Columbia Law School, who will help set the stage for us this afternoon. Professor Posen.
Good afternoon. So as you've heard, my role today is to set the stage, and I'm going to try to do this at two levels. First, I'll take a few minutes to review the factual and procedural setting of the appeal in the Judith Miller case, and second, I'll spend the remainder of my time providing some broader background on the debate over a reporter's privilege. Let me start with the facts behind the litigation. I should note at the outset that the events that led to this appeal were unusually complex and convoluted, indeed cinematic. So while I will try to convey a bit of the drama behind the case, this review will necessarily leave a lot out. The story begins in February of 2002, when a former diplomat named Joseph Wilson traveled to Niger at the CIA's request to investigate whether Saddam Hussein had tried to purchase yellowcake uranium ore from that country. On July 6, 2003, a little over a year later, Wilson published a famous op-ed in the New York Times titled, "What I Didn't Find in Africa," in which Wilson stated that the Bush administration had twisted the intelligence related to Iraq's nuclear weapons program in order to exaggerate the Iraqi threat and thus embellish its case for an invasion. 8 days later, on July 14, 2003, the syndicated columnist Robert Novak published a piece in which he identified Wilson's wife, Valerie Plame, as a CIA operative. Following an article by Time magazine to similar effect, on September 28, 2003, a little over 2 months after that, the Washington Post reported that, and here I'm quoting, 2 top White House officials had called at least 6 Washington journalists and disclosed the identity and occupation of Wilson's wife. Well, and they did so in an effort to undermine Wilson's credibility and perhaps get back at him. That didn't sound so good to a lot of people. Among other concerns, the Intelligence Identities Protection Act of 1982 makes it a felony to disclose the identity of a covert agent under certain circumstances. The Department of Justice promptly announced publicly that it was opening a criminal investigation, and given the political significance of the issue, as well as the report that the disclosure had come from upper echelons of the White House, members of Congress and the media began to call for Attorney General Ashcroft to recuse himself from the case. On December 30th, 2003, the Attorney General did just that, recused himself, and immediately the acting Attorney General appointed Patrick Fitzgerald, the U.S. Attorney in Chicago, as special counsel, delegating to him all the authority of the Attorney General with respect to the matter. Now, it was reported afterwards that at the time Fitzgerald took over as special counsel, Deputy Secretary of State Richard Armitage had already told the FBI that he was a source of the leak to Novak. So why not just call it a day? Well, among other things, the FBI had also spoken with Vice President Cheney's Chief of Staff, Scooter Libby, and to make a long story short, there was reason to believe that Armitage was not the only source and that Libby may have been lying, presumably to protect himself or his boss, when he told the FBI that he had not revealed Plame's identity and indeed claimed that he had learned about it himself from Tim Russert of NBC's Meet the Press. Fitzgerald began a vigorous investigation. Some of you may know this history very well. By February of 2004, a federal grand jury was interviewing senior administration officials, including Karl Rove and Scott McClellan. In late May of 2004, the grand jury subpoenaed two journalists, Russert and Matthew Cooper of Time magazine, who had co-authored that initial story after the Novak article, to testify about their sources. Russert testified before the grand jury later that summer, although reportedly he was not asked any questions that would have forced him to divulge a confidential source. But Cooper would not testify, and he was held in contempt by Judge Hogan of the D.C. District Court. That initial contempt order was soon vacated after Cooper negotiated an agreement with Fitzgerald to testify about his conversations with Libby. Less than a month later, however, the grand jury subpoenaed Cooper again, and in broader terms, and this time Cooper, along with his employer, Time Inc., which had received its own subpoena, held firm and refused to comply. Meanwhile, the grand jury also issued two subpoenas in August of 2004 to Judith Miller regarding her conversations with Libby. Miller had never actually written a piece about Plame for her employer, the New York Times, but she had conducted interviews relating to the matter. Miller, too, refused to comply with the subpoenas, and she, too, was held in contempt when the district court denied her motion to quash the subpoenas. Both Cooper and Miller then appealed in a consolidated proceeding, and that's what led to the oral argument that you're about to hear reenacted. And here I need to give a bit of a spoiler, which is that Cooper and Miller lost the appeal. And I'll trace forward a little bit what happened afterwards. After the Supreme Court refused to grant cert in the case, it was sent back to the district court, and on July 6, 2005, Miller was ordered jailed by Judge Hogan after she continued to refuse to testify. Cooper, on the other hand, said that he received a last-minute call from his confidential source, who turned out to be Karl Rove, freeing him to testify and avoid jail time. Miller spent 85 days in jail. She was eventually released after receiving written assurance from Libby that he wanted her to testify, or at least wanted to be on the record, wanting her to testify, which she would do twice that fall. Now, you may be asking yourself at this point, why bother subpoenaing these journalists, and why let it go so far as jail time for one of them? Did Fitzgerald really need to do that, given all the other evidence he was gathering? These questions are at some level unanswerable, of course, but Fitzgerald's position was that after exhausting other avenues, he still needed the testimony of Miller in particular to prove that Libby had lied to investigators before he had taken over the case. And to jump the gun a bit, Libby would indeed be charged in 2005 and convicted in early 2007 on 2 counts of perjury before a grand jury. one count of obstruction of justice before a grand jury, and one count of making false statements to the FBI. So in short, forcing Miller to testify might have enabled Fitzgerald to bring a successful case that he couldn't have otherwise brought, albeit not against any of the other leakers and not for the alleged crime that had triggered his investigation in the first place, but rather for a derivative offense. Whatever you think of Fitzgerald's approach, should he have had the authority as a matter of law to force Cooper and Miller to testify before the grand jury on pain of jail time for noncompliance? Before a panel of this court consisting of Judges Henderson, Sentel, and Tatel, Cooper and Miller argued no. Their lawyers advanced a number of theories why, but most pertinent for our purposes was their argument that journalists have a privilege under either the First Amendment or the common law to withhold confidential information about their sources from a grand jury. Before this court, much of the focus was on the common law claim of a reporter's privilege that you're going to see the counsel talk about in a few minutes. The First Amendment might strike you, however, as a sturdier anchor than the common law for such a claim. But the problem for Cooper and Miller on the First Amendment side was the Supreme Court's decision in 1972 in the case of Brandsburg versus Hayes. Because in Brandsburg, the court had held that the First Amendment does not exempt journalists from appearing before a grand jury pursuant to a valid subpoena, at least when that subpoena wasn't issued in bad faith for the purpose of harassment. Writing for the majority, Justice White said, and I'm quoting him, "We cannot seriously entertain the notion that the First Amendment protects a newsman's agreement to conceal the criminal conduct of his source or evidence thereof on the theory that it's better to write about crime than to do something about it." True, this passage did not expressly foreclose the possibility that a newswoman's confidentiality agreement would receive First Amendment protection, but that looked like a tough argument for Miller to advance. In any event, she was consolidated with Cooper. Notwithstanding Justice White's analysis, however, by the time the Miller case was argued, there actually was some support in the case law for the idea that the First Amendment furnishes a qualified reporter's privilege in at least some settings. Qualified in the sense of being defeasible if the government's able to make certain showings to a judge's satisfaction about its need for the information. Seizing on Justice Powell's famously cryptic concurring opinion in Brandsburg, in the 3 decades after that case, numerous federal courts recognized the existence of a qualified First Amendment-based reporter's privilege in both civil and criminal contexts. Professor Ronell Anderson Jones has called that line of precedent one of the most remarkable legal developments in the history of media law. Remarkable because whatever Justice Powell might have believed, he joined Justice White's opinion in full in Brandsburg, thus making 5 votes for the no privilege position. In 2003, the year before Cooper and Miller's appeal was argued here, an obscure federal judge named Richard Posner authored an opinion for a Seventh Circuit panel in which, as Jones put it, he blew a bold gust of wind at the neatly constructed house of cards that media attorneys had built out of Brandsburg. Some of the post-1972 cases, Posner charged, essentially ignore Brandsburg. That's a quote. Some, another quote, treat the majority opinion in Brandsburg as just a plurality opinion. And some, Posner said, audaciously declare that Brandsburg actually created a reporter's privilege when it did no such thing. In short, if Judge Posner was right, then any First Amendment-based claim of a reporter's privilege, at least in a grand jury setting, was and still is simply foreclosed by Supreme Court precedent. Nor was there any federal statute that Cooper and Miller could turn to. As early as 1929, there was a bill that was introduced in the U.S. Senate that would have created a reporter's privilege. And in the wake of Brandsburg, these legislative efforts took on new urgency. By one count, over 50 reporter's privilege or media shield bills were introduced in the House of Representatives alone just in January 1973, in 1 month. Moreover, at the sub-federal level, about 2/3 of the states would go on to adopt media shield statutes, with virtually all the rest recognizing a reporter's privilege on common law or state constitutional grounds. None of the federal bills, however, for a variety of reasons, became law. Perhaps above all, the consistent opposition of the Department of Justice operated to thwart these legislative efforts. Much more recently, after Brandsburg, another promising window, I'll just note quickly, for a possible federal shield law opened under the Obama administration, especially after several controversial developments in 2013, including a Fourth Circuit ruling against reporter James Risen's claim of privilege, reports of the Justice Department seizing AP reporters' phone records, and the Justice Department's receipt of a search warrant for the emails of a Fox News reporter, James Rosen. It looked as if we might have a real chance at a federal shield bill late in the Obama administration, but that too didn't end up getting enacted. Instead, what we got was executive branch reform. The Justice Department's internal guidelines on issuing subpoenas to the media were modified in 2014 and again in 2015 in consultation with representatives of the news media. These guidelines actually predate Brandsburg. They were first announced in 1970, although they only entered the CFR in 1973, and they've stuck around. They prohibit the use of media subpoenas except as a last resort and with the express authorization of the Attorney General. And these guidelines, although not a statute, seem to matter in practice, at least if the Justice Department's own data are to be believed, and I should note there is some debate about the numbers. The department approved the issuance of subpoenas to reporters seeking confidential source information in only 19 cases from 1991 to 2007, or just over one such subpoena per year. New York Times legal correspondent Adam Liptak wrote enthusiastically in 1999 that the DOJ guidelines amount to a shadow federal shield law that is sensible, rigorous, and predictable. So we have no statute, but we have the DOJ internal guidelines. And to be clear, there may be good reasons to prefer a federal statute to these self-imposed rules, which judges do not enforce. But as a descriptive matter, it seems clear that the DOJ guidelines have constrained federal prosecutors to some degree, and in so doing have undercut some of the momentum for a legislative solution. To return things to Miller now, it's important to see, however, that the guidelines were effectively loosened in the case of Cooper and Miller. And the reason is that the Attorney General's recusal and subsequent delegation of all his authority to the special counsel meant that Fitzgerald didn't need to ask any politically accountable official's permission before issuing media subpoenas. He could just do it on his own. And that gives us a taste, I think, of what the world would look like should the guidelines be repealed and enforcement against classified information leakers be prioritized. Finally, I think it's also important to see that the Miller case is not a textbook example of why people think a reporter's privilege might be vital. Setting aside thorny issues about who's a journalist and how exactly any balancing test would be structured under a qualified regime, the basic argument against the privilege in a grand jury setting is, of course, that it might impair the government's efforts to prosecute crimes. Against that possibility, the basic argument in favor of a privilege, of course, is that without it, sources might be afraid to speak with journalists, thus chilling the contributions of whistleblowers, impairing media coverage of powerful actors and institutions, and impoverishing democratic discourse. In the Miller case, however, the sources whom Cooper and Miller were trying to protect were not whistleblowers seeking to shine light on government misdeeds. Rather, the sources were themselves extremely high-level government officials who, it seems, were seeking to destroy a whistleblower and deflect attention away from the government's misdeeds. And they did this, moreover, by revealing a certain sort of fact, the identity of a covert agent, That, as a general matter, has little, if any, democratic value, yet significant potential to cause harm to that individual and the intelligence gathering work of her agency. So if you were looking for a case to put the idea of a reporter's privilege in its best light, let me suggest this is not that case by any means. But it is the case we have, and the legal and policy issues it raises are very much still with us. So without further ado, we now call for argument before the United States Court of Appeals for the District of Columbia Circuit, Judges David S. Tatel and David B. Sentel, the case of In Re Grand Jury Subpoena Judith Miller, number 043138.
Good afternoon, Your Honors. My name is Laura Handman. I'm with the firm of Davis Wright Tremaine, and today I represent Matt Cooper, the White House correspondent for Time Magazine, Time Inc., and Judy Miller, Pulitzer Prize-winning investigative reporter at the New York Times. Both of the reporters are facing up to 18 months in jail. And Time Inc. is facing a fine of $1,000 a day for contempt for refusing to comply with the grand jury subpoena. We are here today at a crucial moment in our nation's history. The need for a vigorous, vibrant, independent press has never been more compelling. I respectfully ask the court today to recognize a common law reporter's privilege that would apply in criminal cases, both grand juries and trials, as well as civil cases, informed by the important First Amendment interests put at risk when journalists are compelled to reveal their confidential sources. No less than Judge Skelly Wright in the Zarelli case recognized that compelling a reporter, he said, to disclose the identity of a source may significantly interfere with this news-gathering ability. Journalists frequently depend on informants to gather news, and confidentiality is often essential to establish a relationship with an informant. We have the Pentagon Papers as an example of a case of a report that depended on a confidential source. We have the Watergate unmasking of presidential misdeeds. We have Abu Ghraib, the unmasking of torture in Iraq, as three examples of stories that might not have come to light but for the ability to protect a confidential source.
Are you seeking an absolute common law privilege or a qualified one?
Your Honor, we have made the case for an absolute privilege in the sense that the certitude that you get with absolute privilege really goes to alleviate the chilling effect that can occur when you don't know, when you're talking to a source, am I going to be able to uphold this privilege? Am I going to have to go to jail in order to do that? And gives the source a sense of certitude. But we recognize that it may well be that the court is only prepared to give a qualified privilege, and we think that would be certainly more protection and necessary protection in order to go forward, and would allow the kind of balancing that both this court has recognized in the civil context in the Zarelli case, and as Justice Powell referred to in the Brandsburg case as well.
You speak of the Brandsburg case. You said a moment ago that this common law privilege is to protect First Amendment values. Are you here making a First Amendment argument or a common law argument?
My focus today is on the common law, Your Honor. At the time of Brandsburg, Justice White said that it had not been recognized at common law, but he also acknowledged that Congress could indeed fashion standards. And what has happened since Brandsburg, 5 things have happened that make the case for common law particularly compelling. First of all, Congress delegated that power to fashion testimonial privileges to the courts under Rule 501 of the Federal Rules of Evidence that was passed 3 years after Brandsburg, specifically giving this court and others the flexibility to recognize privileges. The second thing that's happened since Brandsburg is that we now have 49 states that recognize some protection for reporters.
I think, before you go through your whole list, another thing that's happened since Brandsburg is the question of who's a journalist. At the time of Brandsburg, we knew who a journalist was. They worked for the Washington Post or the New York Times or NBC. But today, and the concept of a privilege at that time made sense because we knew who it applied to, but what is a journalist today? I mean, everybody's releasing news of all kinds and writing all kinds of stories on all kinds of platforms. How do we know what a journalist is and who's entitled to that privilege that you're articulating?
Your Honor, that's a very good question, and definitely courts and legislatures have struggled with it. But in the 33...
You're asking us to actually apply it. You want this court to articulate a qualified privilege that would require us to balance, right, the value, the harm of the leak against its value for journalists. I mean, what about someone with a Twitter feed? Is that a journalist?
Well, Your Honor, to begin with, the reporters that are before you today, there's no question that they fit anybody's definition.
No question about it, but we have to know what the consequences of this privilege is, correct? I mean, sure, Judith Miller and Cooper are both, by anybody's standards, serious journalists. But if we articulate or develop a common law privilege that will be applicable, at least throughout this circuit, then other, quote, journalists will take advantage of it. And how do we know who they are?
Your Honor, the courts have looked to, including the Second Circuit and the statutory definitions, a functional test. Is the person intending to, when he begins to gather the information, is his purpose to disseminate it to the public? Is that in the function that he is performing when he talks to his sources in order to gather information? And whether the platform be online, BuzzFeed, or whether it's the New York Times, that's the function of the journalist, and it's a function test, and that I believe on a case-by-case basis, you'll be able to flesh that out.
Insofar as you're relying on First Amendment values, the First Amendment doesn't speak of journalists. It speaks of the press. And at the time of the adoption of the Constitution, and more specifically the Bill of Rights, we did not have a large body of professional journalists, and is it not in fact the case that by inclusion along with rights of free speech and freedom of religion, the framers were creating not a right for a privileged group of professionals, but rather a right for anybody who chose to use a press?
Well, Your Honor, you're correct that it dates pre-revolutionary days when John Peter Zenger refused to reveal his sources as he sat in prison for criticizing the British governor of New York. He was a pamphleteer, I believe.
Nonetheless, do you really think that they thought that Zenger had any more rights than Paine or the authors of the Federalist Papers or anybody else who owned or could hire a press and print?
Well, as I said, I think the test is looking at the function. If we're trying to encourage reporting and public information about our government, who is functioning in that role? And you look at what is the journalist actually doing, or what is the person actually doing?
I understand you to be answering my question. In fact, does not the right of freedom of the press belong to anybody who is using the press? Just as the right of freedom of speech is not restricted to professional speakers, the right of freedom of religion is not restricted to clerics, is not the right of freedom of the press available to anybody who can use a press?
I agree with you that it doesn't require a credential in order to be deemed someone who's functioning as a disseminator of public information about the government.
Therefore, why should we discern that, as Justice White dealt with, that there was any intent to protect a special class of people as opposed to special class of professionals, as opposed to a right that's available to all under the American Constitution?
Well, as you know, there's freedom of press is distinct from other First Amendment rights.
I know no such thing. Don't tell me as I know no such thing. I wrote a whole article for the Cato Supreme Court Review on that, after all. And Professor Bollock's written on it, that there is no case in the early days of the Constitution that distinguishes between the right of the professional journalist and the right of anyone else, as Judge Tatel suggests, of anyone else to use the press to exercise that freedom. Well, if that's the case, then how can we say that there is a special privilege afforded to a special class of people?
Well, as I said, if it turns on what is the function and not whether you have the credential, whether you get a paycheck from a news organization or not, but what are you in the process of doing, and why are you connecting to your sources?
I suppose I'm a blogger, and I wish to inform all those people who surf past my blog of these facts about what their government's up to. Should I not have the same freedom of the press that somebody with the money to buy a newspaper has?
Someone who's in the business of blogging I think, would indeed receive...
Why do they have to be in the business of blogging? The writers of the Federalist Papers were not in the business of writing papers. They were lawyers, merchants. One of them was a smuggler, maybe, I don't know. But anyhow, they were not professional journalists. And do you really think that the freedom of the press didn't protect them? Or wouldn't have protected them if they'd come in the opposite time order, excuse me.
I don't think the occasional guy who blogs, from his garage, as I think Your Honor has used as an example on occasion, if it's just on an occasional basis he's doing it, I'm not sure he would get the same protection or need the same protection.
You see, I want to change the subject a little bit here and ask you exactly how this balancing would work. That's what you want. You want us to articulate a qualified common law privilege in which, in a leak case, we balance the harm of the leak against its newsworthiness, right? That's basically what you're asking us to do.
Correct, Your Honor. Where you both make sure that the government needs this information, as is articulated in this court.
I understand. It's really easy to describe that balancing test, but we will have to actually apply it. And I want to ask you how you would do it in this case. So today's papers are full of articles about the concern the president has about leaks from the White House. So suppose the president authorizes a leak investigation, they convene a grand jury, and they subpoena Philip Rucker, the White House Washington Post reporter, who's written 4 articles in the last 4 days, full of anonymous White House sources, reporting everything from, he reports that Flynn, the national security advisor, is vulnerable to Russian blackmail, that he's about to resign, that the chief of staff is, quote, in over his head. I could go on and on. There's at least 8 or 9 different anonymous sources in that. So the grand jury subpoenas Rucker, and we get the case. How do we balance that? How do you balance the harm of that leak against its newsworthiness?
Your Honor, I think that is a very good example of exactly how that balance would work. Assuming
don't tell me I know how you would balance it. I know your conclusion. Tell me how this court would do it. How do we do that? I mean, we're right here. We're just 2 different judges. There's many more federal judges who would hear these cases. Do we just do it based on our own instincts? I mean, Judge Santel and I might have very different views about whether that particular leak that information is valuable or not, or whether it's harmful. I don't see the standard that we would how we would do that.
Your Honor, the courts do apply a newsworthy matter of public concern standard to many different sectors of First Amendment law. For example, in the Bartnicki case, where there was unlawful wiretapping that the radio station received, and the court said that can't be punished because it's a matter of public interest. And so the court engages in that evaluation. And in the case that you mentioned of Mr. Flynn, the question would be raised, would his resignation have actually even happened but for the leaks? There, the leaks are crucial to informing the public, to bringing about accountability in government.
Where do you put into your calculation the president's need to have an atmosphere within which he can function confidentially? Is that a value we balance?
Well, there is certainly administrative remedies and other remedies that can be exerted against the employees who have signed loyalty requirements. But the journalist who gets that leak, he needs to, or she needs to bring that to the public attention. I think in Ms. Miller's case, for example, she won a Pulitzer for documenting the threat of Osama bin Laden in January of...
That's not this case. So, Ms. Hamden, your time's up, and so we'll hear from Ms. Jeffers.
Thank you, Your Honor.
Thank you very much.
Good afternoon, and may it please the court. My name is Amy Jeffress, and I am arguing today on behalf of the United States that this court should not take it upon itself to overrule Brandsburg versus Hayes and establish a common law reporter's privilege. And there seems to be consensus that at the time that Brandsburg was decided in 1972, there was no common law reporter's privilege. And the core principles on whether a reporter should have a privilege against testifying in a criminal case have really not changed since 1972. There are, granted, very important values at stake. The press plays a critical role in our society, the press must be free, and the press depends on confidential sources. All of that was true in 1972, or stated another way, none of that is new since 1982 to justify making such a significant change in the common law. Now, the appellant argues that this court should now recognize a common law privilege because of two developments. One is the enactment of Federal Rule of Evidence 501, which appellant characterizes as delegating the power to enact a privilege to the courts.
Accurate?
In this situation, Your Honor, I do not think it is accurate.
No, I was asking you the general question. You seem to be challenging the fact that 501 is a delegation of authority to the federal courts to fashion common law privileges. Is that not accurate? I know you don't think there should be one here, but isn't that what 501 is?
What Rule 501 provides is that the common law can be interpreted by U.S. courts in light of reason and experience. And the Jaffe case is actually a perfect example of how the courts properly applied Rule 501, because in that case, there was an existing privilege, the doctor-patient privilege, which the court then applied to a new category of licensed medical professionals, psychotherapists, which truly did not exist when the doctor-patient privilege originated, whether that was back in medieval England or in U.S. history somewhere along the way. So that's taking an existing privilege and adopting it in an evolutionary manner, not creating a common law privilege where there never had been one since prior to
Jaffe relied on the uniform judgment of the states. And here you have 47 states that have developed a reporter's privilege of some kind. It doesn't seem to be any different.
Your Honor, that is correct, and that, I would say, is the strongest point against my argument that there should be no common law privilege, that in fact...
We have recognized, and other federal courts have recognized, a limited privilege, at least, in civil cases. Is that not an exercise of the 501 power that opposing counsel suggested exists?
It is, Your Honor, that's correct. It is. The Zerilli case, which the appellant cited, is in fact an example of that. The Zerilli case, however, did not overrule Brandsburg versus Hayes, which is what appellant is.
Brings us back to what Judge Taylor was asking you. That has to do with this specific case, but you're not disputing the possibility that the courts have the power to discover a common law privilege that did not exist before 501.
And Justice Powell himself said that in his concurring opinion.
Justice Powell's concurring opinion is very enigmatic, as it's been described.
That's for sure.
It does not, however, recognize a privilege.
No, it doesn't. You're totally right. It does not. There is no First Amendment privilege. But he does, in his concurring opinion, leave open the possibility that Congress or the courts could develop a common law privilege.
Your Honor, what his opinion suggests about the First Amendment is really that courts need to be very careful because they need to recognize that there is a First Amendment and that there is freedom of the press. And in handling motions needs to balance the competing interests that judges always handle, whether handling a motion to quash a subpoena in any context. Judges need to be cognizant that there is a right to freedom of the press and balance that in a different way than it would other competing principles at stake.
You know, when you opened, your first sentence, you acknowledged the importance of freedom of the press. Why are you so sure that that if there is no privilege, why are you so sure that reporters don't need we don't need a privilege in order to promote the free flow of information? How are you so sure that sources won't be chilled without a reporter's privilege?
Well, Your Honor, in fact,
Won't that undermine the very value you started with, First Amendment?
in fact, I think that that's one of the weakest arguments that appellant has, that the absence of an ironclad reporter's privilege will dry up their sources.
Well, no, counsel conceded we aren't going there. We're talking about a qualified privilege, not absolute.
Even without an ironclad qualified privilege, it appears that leaking is alive and well here in Washington.
Definitely. Right?
It was at the time of the original Miller argument.
Right.
And those are among the things that have not changed since 1972, I would argue.
Well, just assume for a minute that at least this judge doesn't accept the argument that Brandsburg really tells you very much about the issue before us. That was a First Amendment question. It was pre-501. A lot's happened since then. As I read 501, it gives the courts the authority to articulate privileges. There's 49 states that have done this. What's the argument against a qualified privilege, other than Brandsburg?
Another argument, Your Honor, is that this is inherently a policy decision that is better suited to legislatures.
Congress
than to
delegated
courts.
it to the courts. That's what 501 is.
If I could point again to the Jaffe case, there you had a decision which extended an existing privilege, which had a body of law interpreting that privilege, and that is the doctor-patient privilege. It extended that privilege to a new category of doctors, if you will. So in this case, though, where there really is no common law body of law to apply a reporter's privilege,
The states don't count?
the states...
There's no federal
the
common law that I'm aware of, but there's a state, the common law is both federal and state.
Correct, Your Honor, but the disparity among the laws as applied in the states, I think, really proves my point. Some of the privileges in the states are qualified, while some are absolute. Some apply only in civil cases. Some apply both in civil and criminal cases. Some apply differently.
But as a group, they all articulate a reporter's privilege of some kind.
Of some kind. Some apply only to the identification of sources, some are broader, some use balancing tests, and those balancing tests vary. And then they
So
also...
is your point then that we can't, under 501, not only does there have to be uniformity, a uniform common law before we can recognize it, but it has to be precisely the type of qualified privilege that Miller seeks here? I mean, I don't know where you would get that. That's not the way the common law works. I mean, basically the way, as I see it, what you have here is, if you look at the experience of the states, all the states have recognized some sort of reporter's privilege. That's the basic common law. So our question is, before us is, if I don't accept that Brandsburg is decisive here, is that enough to recognize a common law privilege? And your only answer to that seems to be, it isn't, because all the states haven't identified, or haven't articulated just the kind of qualified privilege that Miller seeks here.
So my argument in the first instance would be that certainly none of that supports an argument for an absolute privilege in the grand jury context,
Well, how about a qualified privilege in the grand jury context?
And even a qualified privilege, Your Honor, I would argue is very difficult for courts to define in a way that's meaningful. The other point that I would make is that...
The Jaffe privilege would apply to grand juries. So does the lawyer-client privilege. All the privileges that have been articulated under 501 apply to the criminal law also. Why would we distinguish this case?
There is also the difficulty, Your Honor, of defining who qualifies for the privilege, and that, for example,
that's a problem.
was not the case in Jaffe, where it was
But what do you think
very...
about Ms. Handman's answer to that, which, was, look, we just do it on a case-by-case basis, and basically the question is, we ask whether the person who's seeking the privilege is someone who's legitimately trying to inform the public. Why is that a bad idea?
It could cause havoc, Your Honor, because as you pointed out earlier, almost everyone has a Twitter feed today, and that means that almost everyone could argue that they are a journalist and entitled to privilege in their...
Do they have to be a journalist in order to have freedom of the press?
So it would be slightly easier if there were a way to define journalist that would confine the
Would it
privilege.
not be easier if we say everyone has the freedom of the press and therefore there cannot be a special privilege?
Then everyone's entitled to the privilege,
Or no one is?
or no one.
Suppose I want to push you a little bit about your argument that there can be no privilege at all with respect to a grand jury. Suppose instead of seeking, in this case, from Judith Miller, her source, this particular source, in this particular case, suppose the grand jury were trying to find out the source of her Pulitzer Prize-winning story on Osama bin Laden. Now, you're not serious, are you, that the court would force a reporter under those circumstances? I mean, I mean, unless you can tell me that there's some current harm from that information. I mean, that was an extraordinary revelation of information that the public had no idea of, that Osama bin Laden was a serious threat to the United States. No one knew that. And you're telling me that a court would force her to testify as to the source of that leak?
So, of course, Your Honor, in the context of a grand jury subpoena, there has to be a crime under investigation, and this is akin
Well,
to...
maybe they're trying just like this case. Maybe they did an internal investigation, and the potential source is thought by the FBI to have lied to the agents or to the grand jury itself about whether he or she was the source. So let's just like this case. They're investigating a serious crime of perjury. Would that, in your view, outweigh the value that the public gained from Miller's series of articles on Osama bin Laden, for which she won the Pulitzer Prize? We would order her to reveal that source and jail her if she didn't?
So, Your Honor,
You don't
You're
really
asking
mean
me
that, do you?
You're asking me to apply the balancing test. I would argue that I am not qualified to...
No, excuse me, your time's up, but I'm not asking you to apply the balancing test. I'm asking you wouldn't want us to apply the balancing test. Under your view, we would have to enforce that subpoena because presumably the Justice Department would only ask for the subpoena if it couldn't get the information any other way. And obviously, when you have a leak and a reporter, basically the only way you'll get the information is by enforcing the subpoena. That's my only question. I'm just testing your theory that we don't need a privilege at all. And can you give me a legitimate reason why a court would enforce the subpoena in the Osama bin Laden case?
Your Honor, if the court took the position that there was an absolute privilege, then that would be a very different case. My argument is that there is no privilege here, and that the court should not overrule Brandsburg.
Thank you both. Your time is up. I don't know. Speaking for myself, I sure wish these two had argued the case 10 years ago.
I don't think we allotted enough time for this
Right.
case.
I think so. You were both superb. Thank you very, very much.
My name's Stuart Taylor. Copies of the bios of our distinguished panelists should be available to you. All have deep experience on issues of reporters' rights to protect confidential sources, particularly in federal grand jury investigations into leaks of classified national security information. The ground rules are, for answers to my first question to each panelist, we've agreed to a strict 3-minute time limit. The time limit for all subsequent questions, including any responses to what others have said, will be 2 minutes. If a panelist goes over a time limit by 20 seconds, I will hold up this sign in a spirit of futility. So I'll start with a question for Laura Hanman. And it's a hypothetical based on the current status of National Security Advisor Michael Flynn. Suppose that before any of this was public about Russia and so forth, a major newspaper has sought your advice on whether it would be safe to publish a major, very reliably sourced story that, according to 3 unidentified senior national security officials who were talking only to you apparently, or to your reporter, Flynn had discussed sanctions with the Russian ambassador during the Obama administration, then misled Vice President-elect Pence about it, and that President-elect Trump knew about this fairly early on. What would you have advised, both as to whether the sources could be protected if they published this, if the newspaper published this, and also whether the newspaper itself might be in jeopardy if it was all alone putting out this story?
Well, first of all, it clearly is an incredibly newsworthy story. And our mission is to publish newsworthy stories. And that's what we would do. And if we were confident in our sourcing, which in your hypothetical we are, we would definitely publish it. We would think about the fact that could well face a leak investigation. We could well face a grand jury subpoena. We could well face, just as Judy Miller did, potential jail time, because we would uphold our commitment to our confidential sources if they hadn't released us from our obligation to do so freely and voluntarily. But we would publish it because that's what we do in a story like that, cognizant of the risk, but that we would publish that.
Thank you. Question for Jim Cole. Have the courts, I think we've heard something about this, but just to clarify it, given your recent status as Deputy Attorney General, have the courts allowed any reporter's privilege at all in the context of national security investigations in the D.C. Circuit or anywhere else? And a second part, aren't the Justice Department's self-imposed guidelines on seeking information from reporters far more protective of reporter source confidentiality than the courts have been?
I think your question actually is related. Both of those parts are related. To my knowledge, during the time that I certainly was at the Justice Department, we did not have any situations where the courts found a qualified privilege, a common law privilege. I could be wrong, but my sense is that I think I'm correct, and some of that is because the cases that we would bring to the courts had to go through a fairly rigorous process before we would even authorize the issuance of any process in the case, and then authorize the issuance of some sort of compulsion by the courts. And I think a lot of that had to do with what you were talking about in the first instance. What kind of harm was there from the leak that we're looking at? And one of the big issues that we tried to put into the guidelines before we would even proceed was a commitment from the Director of National Intelligence or the intelligence community as to, number one, a statement of, and they had to articulate to us what that harm was, and we had to be convinced that, in fact, it was a real harm that was done, and not just, well, it's a leak and we hate leaks and therein lies the harm. But there was a harm to national security that could be articulated, and a commitment from the intelligence community that they would stay with the case, because we had had some situations where the intelligence community backed out. The second part of your question, yes, I think that the revisions we made to the guidelines, as Professor Posen put it, it's a shadow shield law. And in fact, as we started to amend those guidelines in 2014 and 2015, it really put in a number of the things that the shield law put in, but not everything. And we were, in fact, supportive of Congress passing a shield law at that time that would add the various aspects that couldn't be done just by regulation.
Thanks very much. Question for Amy Jeffress. When you were a federal prosecutor involved in leak cases, did you or the FBI agents or your colleagues find the Justice Department guidelines we've just been talking about that protect sources to be a major obstacle to prosecuting leakers? Should the guidelines be changed in any way, in your opinion?
Well, when I was prosecuting these cases, it was the earlier set of guidelines, although they were still there were still prescriptive elements that you had to meet in order to justify any subpoena or request to the media. And no, I did not find them to be an obstacle to bringing these cases. It was sometimes difficult to get the approval through the Department of Justice, and that at times was difficult, but the guidelines themselves were not an obstacle, I would not say. I'd say they were fairly balanced and appropriate.
Everything got held up in the DAG's office.
And you think they're okay?
That's the old stuff.
And of course, they're only as good as people adhere to their requirements. And part of what occasioned the revision of the guidelines to strengthen them was, as I think Mr. Cole would agree, certain lapses in the application of them.
Just a moment. To David Posen, the Obama administration famously prosecuted more people for national security leaks, a lot more, than all predecessors combined. What explains that, do you think?
I can't, no one can be sure. I suspect it's overdetermined, but could be any number of factors, including 2 inherited cases, the creation of the National Security Division within the Justice Department in the mid-2000s, making another entity other than the FBI responsible for criminal leak investigations that I think was more aggressive than the FBI had traditionally been. The desire of the White House, I think, actually to stay away from DOJ, well-intentioned after criticism of the Bush administration for meddling, I think actually reduced the amount of political pushback that there normally is on leak investigations. Some exceptional cases, new technologies making it easier to find the leaker without subpoenaing a journalist, and some elements of that storm. I will note, though, that the system seems to have been self-correcting in that in the second term of the Obama administration, you not only saw the revision to the DOJ guidelines we've been discussing after controversial uses of prosecutorial authority, but also the ebbing of this tide of prosecutions you're discussing. And at least until we got into whatever paradigm we're now in, which people may want to discuss, I would have said that we ended the Obama administration kind of reestablishing something like the prior equilibrium.
Thank you.
One point to that.
Yeah, sure.
You were asking before about my experience as a prosecutor, and I know that there was considerable anxiety in the media during the Obama administration about these cases. I just wanted to make the point that as a prosecutor, it was never my view that the leak was the fault of the media. The media are doing their job. The leaker is the government official who's entrusted with the national security information, which that person should not divulge. And so I understand the criticism of the Obama administration for bringing these prosecutions, but they were not targeting the media as the defendants in these cases. And I think that would be very dangerous, and that is not something that we ever contemplated doing when I was in the U.S. Attorney's Office.
Thanks. That also relates to my next question for Laura Handman. Do you expect that President Trump, who calls the news media a bunch of liars when he's in a good mood, might far surpass the Obama record on leak prosecutions and subpoenas? And if so, might the need for a judicially enforced reporter's privilege soon become stronger than ever before?
That certainly is my working theory at the moment, that A, you see a multitude of leaks, B, you will see a multitude of leak investigations. What flows from a leak investigation is the subpoenas to reporters, even if they've gone through all the up to Attorney General Sessions now for approval. And what is perhaps most troublesome is, as Amy was just referring, it's never been that journalists have been prosecuted in any way, shape, or form for the leak itself, for disclosure of classified information. And whether this administration takes that final step is one that is particularly chilling if that were to come about. The Espionage Act is itself a very loosey-goosey law, and luckily it's never been applied, and I don't believe this court would sustain such an application, but I refer to our illustrious judges for that point.
We don't deal with that.
To Jim Cole, do you think that there should be, that I think your administration supported a congressionally established privilege. In your personal view, do you think that privilege should have about the same contours as the Justice Department's current guidelines? How broad should it be? Should it be qualified or absolute? And also, I think there was talk during your administration of whether Julian Assange should be prosecuted. He seems somewhere in between a reporter and something else, maybe an agent of a foreign power perhaps these days. But how do you feel about that?
I don't know if I can do that in 2 minutes, Stuart, but
Take a little more.
I'll do my best. On the first part of it, yes, we thought, and for good reason, that there should be a media shield law. And I think the main reason is, and this is something that I think really ran throughout the Obama administration, we wanted to put things into law so that they would have some lasting power and that they wouldn't be based on the policy whims of an administration, but instead would be a product of thoughtful deliberation in the Congress, working out the parameters of some very sensitive issues, and coming out with a piece of legislation that would be lasting and that would be perpetual. The concern we have, obviously, is we think the contours that we put into the media guidelines that finally came out in 15 strike a good balance. They can't go all one way. They can't go all the other way. You have to have room to find harms that do exist and take steps to deal with them. You have to also allow a wide latitude for reporters to do their jobs and to have sources. But these are regulations. These are put in the CFR. They can be pulled from the CFR very easily through executive action. And I think that we want to make sure that there is something actually enshrined in statute to preserve this balance so that people can, like in your question to Laura, people can predict what's going to happen. And it's not just the vagaries of which administration is in power, it is in fact what the law is. And this brings us back to one of the main themes of why we're all sitting in this courtroom, is the rule of law is one of the most powerful and sustaining aspects of our society. And that's found more in statute than it is in regulation or in policy. But I think that our guidelines pretty much got it right. I think we have no monopoly on wisdom or ideas in any of this, and I think that if the deliberations continued in the Congress, there may be some additional good ideas that could be put into it, but I think by and large the balance we struck is the right balance.
Thank you. Amy Jeffress. My old friend Michael Kinsley did some damage to his popularity ratings among fellow media people when he wrote in 2014, quote, "The private companies that own newspapers and their employees should not have the final say over the release of government secrets or get a free pass to make them public with no legal consequences. In a democracy, that decision must ultimately be made by the government." Was Kinsley right or wrong?
Oh, I'll go out on a limb and say I think he was right. And I know it was unpopular, but I do think, I have to say, though, that at the Department of Justice, we often dealt with media organizations which would approach the government and say, we have this story and we're worried that it is going to be damaging to national security if we print it. And papers like the New York Times and the Washington Post do have those relationships, and they will do that. And I think that that is, the ideal exercise of responsible journalism. Those are helpful conversations, and I think the government also handles them appropriately. And sometimes the government will say, we really think that this is something that you should not print, and the papers won't print it. Sometimes the government says, we think this is something you should not print, and the papers go forward with it anyway. But sometimes they tailor what they say in order to protect true national security information. So I've seen it play out in a way that I think, for people who don't know the details, you'd be pleased to know that this is going on behind the scenes.
Thank you. David Posen, your fascinating article, the Leaky Leviathan Law Review article, takes off a little bit from the privileged discussion we're having to discuss something broader. You distinguish leaks from plants, and you distinguish both from pleaks, which you can define for us. You also reason that every president needs to be able to orchestrate lots of plants, and that a serious crackdown on leaks would make plants less effective. I hope I'm being clear here. And that helps explain the paucity of prosecutions and subpoenas relative to the massive amount of leaking that goes on every minute of every day. Could you translate my summary into English?
I'll try. So a plant in common parlance is an authorized disclosure, usually from on high in the administration, anonymous disclosure to the press. A leak is an unauthorized such disclosure. A pleak, my neologism, is something in between. Not clearly authorized, but not clearly disapproved of either, usually done by fairly high-level officials. The article basically claims that most of the action actually is in the pleaks. There are some clear leaks, clearly unapproved disclosures that happen. There are some clear plants, and this Miller case may have involved them, but actually there are a lot of legally and bureaucratically ambiguous disclosures that occur and that are really the currency of a lot of Beltway journalism. And one of the article's claims is that one reason you don't see more enforcement of the laws against leaking is that so much of it is happening in this ambiguous space, which makes it difficult to build a case. It makes it awkward to try to ferret out who spoke to a reporter in many cases, and generally also makes the leaking that happens, I'm calling leaking, all planting, leaking, not necessarily so bad for the executive branch on net. Even if specific disclosures cause harm, the ecosystem of disclosures actually yields a lot of benefits, not just to the public, but to the executive branch. The article has been many, many pages elaborating those claims, but that's a nutshell. I'll just say, though, that the basic mechanism for why you need to allow some leaking if you're a rational executive branch and you want to do some planting and pleaking is you can't have it be the case that everyone knows when they read an anonymous source in the newspaper that it's a deliberate effort of the White House to tell you what to think. That would destroy the whole strategy. You need to preserve some ambiguity about who actually spoke. Were they authorized? Are they speaking authentically in a whistleblower mode, or are they speaking more strategically in a policymaker mode? So you need to have some play in the joints, and that helps explain the low level of enforcement traditionally. And that point is clear. It frames all of what we've been talking about, just deserves a brief mention, which is that by all accounts, there has been for many, many years a very, very large volume of disclosures that are potentially prosecutable under the Espionage Act, very broadly drafted, not to mention the IIPA, the statute at issue in the Miller case, and others. And the enforcement rate has been, relative to that denominator, really low. That's our tradition. I think it's a proud one, and it's also been kind of mutually advantageous for the press, the public, and the executive branch. But I haven't got into where we are now, but I'll say that as a characterization of the period of the last 50 years or so.
Thank you. To Laura Handman, when you talk to a lot of reporters about their situations, I guess. Do they seem to come in assuming they have a privilege? Is it an unpleasant surprise for them when you explain to them what they have and what they don't have? Do they think that somehow they'll be protected against facing a court order to disclose their sources? And does it matter whether the privilege belongs to the reporter or to the source? We saw in the Libby case, Libby authorizing people, right? Okay, you can disclose that I'm your source. How does that play out?
Well, first of all, of course, most reporters are not on the national security beat in Washington, D.C., and most reporters are protected by their state shield laws and are protected, if you're in D.C. or New York or California, and basically half the states that have shield laws have absolute protections for confidential sources. So most reporters function under that regime. It is the queerness, perhaps, of DC that if the U.S. attorney had been wearing the hat of, I'm enforcing DC law, and had dragged Judy Miller into the Superior Court a few blocks away, he would not have been able to force her to disclose her sources. Come here in the federal court in a federal leak investigation, and she doesn't enjoy that protection. So the savvy national security reporters that are here have seen what has happened most recently in the Sterling case, where the Fourth Circuit said there is no privilege, and Mr. Risen was on tenterhooks for years as to whether he was going to be called as a witness. And ultimately he wasn't, because honestly, just as Judge Brinkema had noticed from the very beginning, the government did not need him in order to make their case. Mr. Sterling was ultimately convicted without Mr. Risen's testimony, and 9 times out of 10, it's gilding the lily. It's not really necessary, and that's perhaps why it doesn't come to blows, but that didn't stop the Obama administration from pushing it to the edge, from trying to make law that said there was no First Amendment privilege.
Thank you. Jim Cole.
To answer your waiver question.
Okay, go ahead.
It is the reporter's privilege. It's not the source's privilege. That's why when the source is asked questions, the source can't say, I'm invoking a privilege. There is no privilege for the source to invoke. It's the reporter's. If the reporter says, and genuinely, without coercion, says, it's fine with me if you testify, maybe it'll be helpful to me, then the reporter is relieved of the obligation, and it's up to the reporter then whether they wish to testify or not. But oftentimes, if you're going around the White House saying, sign this or else you're not going to have a job, or sign this or else you have a target on your back, it's not really a freely given waiver.
Thank you very much. Jim Cole, a question about the damage done by national security leaks, if any. As David Posen has written, many in government believe that, quote, that leaks have collectively cost the American people hundreds of millions of dollars and have done grave harm to national security. Those are the words of the 2005 Rob Silverman report. But others counter that, quote, there's not been a single instance in the history of the United States in which the press's publication of a legitimate but newsworthy government secret has gravely harmed the national interest, to quote Professor Jeffrey Stone. What's your view about how much damage has been done, not by every leak, but by the ones that do as much damage as any others?
There are leaks I've seen that were damaging, and they may not be measurable, but you can talk about them anecdotally as to the kind of damage that was done. In one of the cases that caused controversy that Professor Posen talked about, if a lot of it's classified, but if you believed the news reports that were out about it, there was an outing of an inside covert agent inside Al-Qaeda who had gotten a vest that would be blown up on an aircraft that was undetectable through metal detectors. And that agent, that covert agent, had gotten this, prevented any sort of explosion from ever happening, and preserved the agent's covert nature. The outing of it and the discussion of it in the paper, assuming it was all true, number one, burned the covert agent inside Al-Qaeda. The next time Al-Qaeda did something like this, we didn't have anybody in there. Secondly, it threatened the life of the agent, the covert agent, because people now knew who that person was, as well as the family of that agent. And the question that we had was, what is the news value of this? It was a great scoop. It was a great story. But what is, going to what Amy talked about, what was the news value of the story? What was the importance of the story? And that can be debated, and I'm not going to sit here and say we get into that. But this was an example of what I would call concrete harm that can be done from a leak. And it wasn't a whistleblower doing the leak. The person was caught, and the person was charged and convicted and went to prison for it. It was gossip. That's all it was.
And a follow-up question, apart from that particular case, in your experience dealing with these matters in the Justice Department, Did the media seem to be careful about the distinction between serious journalism and gossip in terms of, do they worry at all about the national security harm that might occur, or do some of them say, not my problem?
Most of the time, I think they did. I really did respect the press, and I respect the responsibility that they had, and many times they did come in and say, I have this story, and I'd like to talk to you about it, and I'd like to discuss whether or not there is any real concrete harm. And we're talking about concrete harm, not just the kind of, oh, we hate leaks and leaks are bad and this will encourage people, but something very tangible. And there were times where the press would not run a story when we asked them and demonstrated to them the concrete harm. Other times there'd be middle grounds. They'd say, look, we can't not run this story, but we can give you an amount of time to remediate the damage, to get your agents out, to undo or protect people that need to be protected, and we'll give you that advantage. We'd like something in return, some exclusive additional piece of information. There were negotiations that would go on like that, and my view was that in the great majority, the press was quite responsible in that way.
Thank you. To Amy Jeffress. Under the Justice Department's interpretation of the 1917 Espionage Act, aren't journalists who publish classified national security secrets felons, along with their sources? And is it a good thing that not one journalist in our history has ever been prosecuted for that? And does that tradition seem likely to endure?
So this goes to the point that I was making before. I don't think that reporters should be the ones prosecuted for the exposure of classified information. They don't take the government job and take the oath not to disclose the information. I do think it's good when they're responsible. You mentioned Julian Assange earlier, and that was a case where there was just a lot of massive publication of a lot of information, some of which had news value, much of which didn't, and much of which was not damaging, but some of which was. And so, the potential is out there because of the way the media looks now and the issues we talked about in the argument about everyone being a journalist. There's the potential for more damage to be done by people who don't have that sense of civic responsibility that I think most journalists, in the way that we traditionally think of them, really do have. But back to your question, I hope the department does not prosecute journalists, even if they can be under the laws, because I don't think that that's really the purpose of the laws. I think that government employees need to, comply with their obligations not to disclose sensitive information, and journalists need to do their job and need to be free to do so.
Stuart, if I can just add, one of the kind of bottom line statements in the Justice Department that I was a part of was, no journalist is going to go to jail for doing their job, period.
And if there are journalists out here and they come after you, I want to defend you.
Thank you. We're down to about 6 minutes left, I think. So I'm going to ask you, David, and then each of you in turn to see if you can spend a minute or a minute and a half saying what you think the law should be on this. And since you've already said it, Jim, I'll try and think of something else to ask you for your swan song. David?
Well, if I may exercise the academic's prerogative to reframe, my whole message in that article that you mentioned is that the law matters a lot less here than people think, actually. So it's, as we heard in the oral argument reenactment, the law has been on the government's side as far as its ability to issue media subpoenas and bring leak prosecutions for a long time. I don't think that's where the constraint inheres in the system. Rather, I think a pretty nuanced set of social norms has been what's prevented journalists from being prosecuted, made it so that they're rarely subpoenaed, although occasionally, and depressed the overall number of leak investigations and prosecutions overall. I think the most important feature of the DOJ guidelines is actually that the Attorney General has to sign off personally before a member of the media is subpoenaed, and the kind of personal accountability that creates. I think the Miller case with Fitzgerald as a special counsel is actually the exception that proves the rule. There you saw what a vigorous leak investigation looked like, and it wasn't pretty from the administration's perspective. It led directly to the White House. He had an awful lot of folks coming before the grand jury, and it was very disruptive from their perspective, and he was immune from the kind of pushback the AG would have gotten. So I guess I would just say that generally we have had Justice Department leadership and White Houses that have wanted to preserve their own flexibility to disclose lots of things, have not wanted investigations to look too deeply into some of those practices, have not wanted to anger the media too much. And that combination of factors, among others, has made it so that we've been able to have a very robust culture of press freedom and relatively low rates of enforcement. If this thesis is right, it's just a descriptive thesis, that these reasons, noble and base, have combined to take us where we are. It's also, it's kind of a fragile system that I'm describing too. And if we have a new administration that doesn't care that much about media pushback, isn't as worried about where leak investigations might lead, and just has a completely different relationship to how it's perceived by the press and the public, then I think that increases or adds weight to the case to legalize some of these norms, whether through a statute or judicial supervision.
Same question to you, Laura, with particular attention to whether the forces that have been cited in the Justice Department guidelines establish a nice equilibrium. If we could just maintain it, things would be fine. Is that your view?
Well, I think it is time to pass a federal shield law. I think the vagaries of politics that have been demonstrated over the last year suggest that you can't rely on basically the good faith of one administration or another to assure a thoughtful restraint when going to subpoena journalists. The chilling effect of the fact of uncertainty is what I think is incalculable at this point in time. And that's why I think the certainty of a federal shield law would greatly enhance the ability of the press to play the watchdog role that they are entrusted with under the Constitution. I'm not as pessimistic as others probably are about the passage of a federal shield law. In my experience, the First Amendment is one place where both parties find common ground. And so I'm hopeful, perhaps unrealistic, but I'm hopeful that we could see indeed right now a shield law passed. Now, would it be absolute as far as constitutional, confidential sources go? That is a heavy sell. It is, of course, the regime that exists now in the states, in most states, or in many states, and has not affected law enforcement. I think that would be hard to get passage of, but I do think when you're doing the balancing that the court will need to do under any shield law, a very high bar has to be set when there's confidential sources about a newsworthy whistleblower type setting, or something as important as War and Peace as was involved in the Judy Miller case.
Thank you. Jim, you've answered the question on the table, just a quick answer to a related one, which is, do you think shield law has a chance? It's been proposed for decades and it's never gotten far.
No.
And do you feel strong? Well, okay. Well, that was concise, and since we're running low on time.
A few minutes. No, I generally think that it's a very controversial issue, and the balancing is very difficult. And I think from what we've seen, and I'll be a little cynical right now, what we've seen in our Congress makes me wonder whether they're going to be up to it.
Amy, your view, and also, I suppose, a related matter is, what would you say to a citizen who says, why should a bunch of journalists have First Amendment privileges that I don't have?
Well, I agree with, I think what everyone else has said is that there should be some kind of protection, some kind of qualified privilege. I agree with Jim that I don't think Congress is going to be able to pass one. Contrary to what I argued, I think that the judges probably can handle these issues responsibly. Judges are, of course, the most intelligent, wittiest, and best-looking people in the world. It is Valentine's Day. So they're up to the task, and my prediction is that while I actually don't think that that's the best direction for the law to go in terms of that there should be a statute, I think the judges are going to have to be handling these questions if there still continue to be problems.
Well, fortunately, I think Judge Santel is still in the room, so you could have a chat with him afterwards. I think we're about out of time. I'd like to thank all of you for your answers to my questions.